For this session, we have Professor Judge Niru Chadha as moderator, who is virtually connected from India. Judge Chadha, are you there?
Yes, I am there.
Please take the floor.
Thank you very much. Good afternoon, everyone. To begin, I would like to thank the Ministry of Foreign Affairs of the Republic of Korea and the Korean Society of International Law for inviting me to moderate today's session. This session corresponds with the theme of the conference, that is Regional Cooperation for Marine Environmental Protection. Given the importance of marine environment to the very existence of our planet, it is necessary that rules regarding its protection and the challenges for their implementation continue to remain in focus. Under the Law of the Sea Convention, the traditional approach to the protection of the marine environment has been sectoral, which regulated marine pollution according to its sources, such as land-based pollution, vessel source pollution, dumping, pollution from seabed activities, etc. The development of new environmental principles and obligations, such as the precautionary principle, the ecosystem approach, and the conservation of biological diversity as a whole, require, however, more holistic approaches to the management of the environment. Part 12 of the Convention of the Law of the Sea utilizes both global and regional approaches towards protecting the marine environment. Section 2 of Part 12 directs states to cooperate on global and as appropriate regional basis, taking into account regional characteristics. This acknowledges the importance of regional regulation, which takes into account specific features and needs of a particular marine area. Despite the progress already achieved in the global and regional regulation of marine environment and ocean resources, gaps in the implementation, interface between different international regimes, and potential overlappings of jurisdictions, and sometimes lack of coverage of threats raise some important issues. Today on our panel, we have several eminent professors who will elaborate on these and several other challenges and success stories. We have three professors who would first speak and then two discussants. I'm advised that each speaker gets 20 minutes and the discussants get 10 minutes each. I will introduce the speakers as we go along. The first speaker on this topic is Professor Margaret Young from the University of Melbourne. Prior to joining the University of Melbourne, Professor Young was a research fellow in public international law in University of Cambridge. She was also a director for public international law at the Hague Academy in 2016. Her two books have been well recognized and awarded. And she works for various organizations like World WTO, Food and Agricultural Organization, and the World Bank. She has presented her research to these organizations. Today, Professor Young will be speaking on protection of the marine environment by flag states, coastal states, and trading states. You have the floor, Professor Young.
Mr. President, members of the Tribunal, distinguished guests and participants, good evening. My name is Margaret Young and I'm a professor at the Melbourne Law School, University of Melbourne. It is a great honour to be presenting at this illustrious conference, and I would like to thank the Ministry of Foreign Affairs of the Republic of Korea, the International Tribunal for the Law of the Sea, and the Korean Society of International Law for the invitation. I wish I could have attended the conference in person in Seoul, but I am grateful to the conference organisers for assisting us in preparing our virtual presentations as we continue the pandemic confinements in our home countries, in my case, here in Australia. My presentation is the first of three in the panel on regional cooperation and marine environmental protection under the United Nations Convention on the Law of the Sea, or UNCLOS. I am delighted to be sharing the panel with the chair, Judge Niru Chadha, and my fellow presenters, Professor Alexander Proles and Professor James Harrison. I have recorded my presentation, which will last about 20 minutes, but will take live questions during the conference proceedings. I am looking forward to the views of the discussants, Dr. Tran Truong Tue and Professor Shim Sang Min. The title of my presentation is Protection of the Marine Environment by Flag States, Coastal States, and Trading States. This contrasts the dominant way in which states assume rights and obligations under UNCLOS, as flag or coastal states, with some different rights and obligations that are assumed when states trade with one another. Increasingly, legal issues surrounding the protection and preservation of the marine environment are expressed in trade agreements. I will show how the general obligation to protect and preserve the marine environment under UNCLOS, as expressed in Article 192 and the rest of Part 12, must be read alongside international trade law, including World Trade Organization agreements, but also regional trade agreements, such as the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, the CPTPP. Most of the world's biggest producers and consumers of fish, for example, are parties to regional agreements such as the CPTPP, so their legal arrangements could have major significance for the marine environment. My aim is to consider what this situation of overlapping legal obligations means for the protection and preservation of the marine environment, a key element of which is the conservation of the living resources of the sea. My presentation is divided into 3 parts. First, I will set out how the relevant UNCLOS obligations sit alongside a selection of trade provisions. I draw primarily on these agreements and relevant case law. Secondly, I consider how cooperation will require special arrangements between international organisations, some of which are novel to the terms of UNCLOS Article 197, using examples from trade measures, fisheries subsidies reform, and marine protected areas. Thirdly, I discuss how compulsory dispute settlement between states might be disrupted in this situation of fragmentation. So let me begin with the first part of the paper, in which I consider the coherence of legal obligations. As is well known in this forum, the general obligation to protect and preserve the marine environment is broadly cast in UNCLOS. It applies not just to the prevention and control of pollution, but to a range of activities. Customary international law principles are also applicable, such as the precautionary principle and the obligations to respect the environment of other states and areas beyond national control. Background context can also be gleaned from the non-binding United Nations Sustainable Development Goals, the SDGs, in which states have set targets in Goal 14, Life Below Water, to sustainably manage and protect marine and coastal ecosystems to achieve healthy and productive oceans. Practical examples of the obligation of states to protect and preserve the marine environment, as discerned from case law, include the obligation not to overexploit living marine resources, which was relevant to ICLS's granting of provisional measures for southern bluefin tuna, to ensure compliance by flagged vessels with relevant conservation measures of a coastal state, as set out in ICLS's advisory opinion of 2015, and to avoid fishing and harvesting activities that harm rare or fragile ecosystems, as relevant to the arbitration brought by Philippines against China in 2016. One can hypothesize about other situations in which the obligation might be breached, such as the escape of 50,000 Tasmanian farmed salmon last week, which generated fears for the health of the local marine environment. Alongside these rights and duties in the law of the sea are rights and duties relating to trade and consumption. Global supply chains and modern trade and transshipment are heavily implicated in the exploitation of the resources of the sea. 38% of fish products, for example, now enter international markets. The rights and obligations that accompany this trade are set out in the WTO and regional trade agreements, and increasingly these obligations seek to include provisions on how the marine environment might be better protected or preserved. To summarise briefly, in global and regional trade forums, states cooperate to provide access to their domestic markets in a non-discriminatory manner. The obligations are largely deregulatory, but policy space is preserved for states to enact conservation and other measures, and adjudicating on the implementation and design of such measures is often left to trade panels or the WTO appellate body. So if states restrict trade in marine products to protect the marine environment, they may be in violation of trade law obligations contained, for example, in the General Agreement on Tariffs and Trade, the GATT, or in regional agreements such as the CPTPP, but they will seek to justify violations by pointing to an agreed list of exceptions. These exceptions, which are contained in the GATT Article 20 and equivalent provisions, will be interpreted according to relevant rules of international law, including UNCLOS. One practical example in which these exceptions were argued in the marine context is the US measure to reduce bycatch of sea turtles by restricting certain imports of shrimp, leading to the well-known US shrimp dispute of the late 1990s. More recently, the EU drew on the public morals exception to justify its ban on the imports of seal products due to concerns about seal hunting practices. Even if such measures are found to have satisfied the policy objective of the listed exception in GATT Article 20, they will be ruled GATT inconsistent if they are designed and implemented in ways that lead to arbitrary or unjustifiable discrimination. Outreach to trading partners through bilateral, regional, or multilateral forums is an important way to satisfy non-discrimination obligations. The US shrimp case, for example, held that the US should have engaged with the complainant states, India, Malaysia, Pakistan, and Thailand, in serious, across-the-board negotiations with the objective of concluding bilateral or multilateral agreements for the protection and conservation of sea turtles. Countries seeking to resolve marine issues thus need to show comparable efforts are made, comparable resources are invested, and comparable energies are devoted to securing an international agreement before imposing trade barriers. Given our interest in this conference in cooperation on a global or regional basis, as set out, for example, in UNCLOS Article 197, this requirement strikes a particular chord. The coherence of legal obligations across UNCLOS and the trade regimes thus rests on cooperative efforts to achieve collective ambitions. I now want to turn in part 2 to some examples of this cooperation. There are a range of examples in which the trade regime and UNCLOS regimes might be said to be cooperating on the protection and preservation of the marine environment. Let me structure this discussion according to the targets stated as urgent as part of the UN Sustainable Development Goals. 3 targets to reach for 2020 were 1, the effective regulation of harvesting and an end to overfishing, illegal, unreported and unregulated or IUU fishing and destructive fishing practices. 2, the prohibition of certain forms of fisheries subsidies. And 3, the conservation of at least 10% of coastal and marine areas, consistent with national and international law. Although the literature includes many other aims and objectives for the global oceans, let me make mention of each of these examples. So let's turn to the first example of cooperation, namely the use of trade measures to end overfishing and eliminate harmful fishing practices. This is not just about import bans if states exceed or do not respect fishing quotas. It is about measures that respond to harmful fishing practices, pollution, bycatch, and so on, thus bringing the aims of the trade measures into close connection with UNCLOS Part 12. The paper provides some details about such measures, including the European Union's regulation to prohibit the import of illegally caught fish based on the failure of exporting countries to address the violations of their vessels. Trade measures to address IUU fishing are the subject of negotiations within regional trade agreements. The CPTPP, for example, recognises that parties may use measures to prevent trade in fish products that result from IUU fishing. Some of these CPTPP parties are not party to some of the major UN and FAO agreements. Parties to the CPTPP commit to supporting, monitoring, control, surveillance, compliance and enforcement systems, including port-state measures, addressing the transshipment at sea of fish or fish products caught through IUU fishing, and striving to act consistently with management measures adopted by regional fisheries management organisations, or RFMOs, of which they are not a member. Parties are to seek to operate a science-based fisheries management system and promote the long-term conservation of sharks, marine turtles, seabirds, and marine mammals. Parties shall also take measures to prevent the pollution of the marine environment from ships. The US-MCA between Canada, Mexico and the United States, which entered into force on the 1st of July to replace the North American Free Trade Agreement, reproduces many of the approaches of the CPTPP, but goes further. In designing measures to prevent trade in fisheries products derived from IUU fishing, parties are to provide other parties the opportunity to comment on proposed measures. In addition to recognising obligations relating to marine capture fisheries and pollution, it includes a novel recognition of the problem of marine litter. Parties recognise the importance of taking action to prevent and reduce marine litter, including plastic litter and microplastics. Parties are to cooperate to address matters of mutual interest with respect to combating marine litter, such as addressing land and sea-based pollution, promoting waste management infrastructure, and advancing efforts related to abandoned, lost or otherwise discarded fishing gear. Clearly, parties envisage an ongoing cooperative forum in which substantive issues relating to the protection and preservation of the marine environment are discussed. A second example of how trade agreements impact on the protection of the marine environment relates to subsidies. Countries currently support their domestic fishing industries with billions of dollars annually. The majority of these enhance capacity of the sector and are used to pay for fuel and other operating costs, or for ship construction. Research suggests as much as 54% of today's high seas fishing grounds would be unprofitable at current fishing rates without subsidies. There is by now agreement across international organisations such as the Food and Agriculture Organization, World Trade Organization, and the United Nations Environment Programme of the need to substantially reduce fisheries subsidies. A coalition of non-governmental organisations, including WWF, Greenpeace, Oceana, and the International Union for the Conservation of Nature, have called on governments to fulfil their commitment by 2020 to curb the public money that supports overfishing and degrades our oceans. Under the WTO Agreement on Subsidies and Countervailing Measures, states have already agreed not to distort markets through certain subsidies. Countries have sought to clarify these rules on fishing subsidies through negotiations. They have done this through the multilateral single package Doha round, currently stalled, as well as through regional trade agreements. More success has been achieved in the Doha round on this topic as compared to other topics, but in regional trade agreements, even more consensus has been reached. I provide more detail on the negotiations in the written paper, but the key point to stress here is that the reform of fisheries subsidies rests on concepts within the law of the sea and is closely linked with the goals of UNCLOS Part 12. At the WTO, countries are seeking to find consensus for prohibition on IUU subsidies. Discussions have toyed with the idea of a country cap on subsidies based on population size. The question of disputed waters has been raised, with a proposed without prejudice clause making clear that the subsidies rules will have no legal implications with respect to delimitation of maritime jurisdiction. Up to now, the regional trade agreements have had more success in reaching consensus. The CPTPP now prohibits subsidies for fishing that negatively affect fish stocks that are in an overfished condition. It further prohibits subsidies provided to any fishing vessel while listed by the flag state or a relevant RFMO in accordance with the rules and procedures of that organisation and in conformity with international law. The US-MCA reproduces and expands on the CPTPP disciplines. The successful application of these rules will depend on the readiness of the states cooperating on shared economic and regulatory objectives, either directly or through the WTO, regional bodies such as the CPTPP Environment Committee, and more traditionally competent international organisations within the UNCLOS regime. As a third example of cooperation that relates to trade law and the protection and preservation of the marine environment, I would like to turn to the Sdg Target of 2020 for the conservation of at least 10% of coastal and marine areas. Having no-go areas provides a check on markets just as subsidy reform does. The negotiations for a new agreement to better conserve the marine biological diversity of areas beyond national jurisdiction promise meaningful developments for UNCLOS Part 12 and is discussed elsewhere at this conference. Although neither the WTO nor regional trade agreements refer to marine protected areas, the closures of fisheries, or the use of area-based management tools, these initiatives may be supported in the future by domestic trade measures. For example, links with trade have been made by academics in response to proposals by some fisheries scientists to close the entirety of the high seas to fishing. Questions have been raised about the major fish-consuming nations clubbing together to refuse imports from the high seas, or countries with highly sought-after markets, such as the United States, taking unilateral measures. While the practices and procedures of states would follow jurisdictional concepts of UNCLOS, trade law would inform the design and implementation of these approaches. In the examples I have mentioned, there is an important question of where and how disputes between states would be resolved, and in this third part of my presentation, I would like to touch on dispute settlement. Although there is not time to go into the points I make in the written paper, it is of no surprise to the present forum that the two major international regimes that allow for compulsory dispute settlement between states are trade and the law of the sea. The consent of states has been crafted very carefully in both regimes. For example, in UNCLOS, disputes on matters concerning the protection of the environment and fisheries disputes are subject to the compulsory procedures under UNCLOS Part 15, with some exceptions including for resource management decisions of coastal states. In the WTO, panels will be constituted to hear all disputes arising from the covered agreements, and the environment provisions of the regional trade agreements are mostly subject to compulsory dispute settlement. A key issue will be whether this careful balance will be disrupted by new agreements in the marine context. In addition to issues of jurisdiction, the applicable law of the tribunals will vary, and there will be a need to interpret underlying treaties with regard to context and relevant rules of international law according to the Vienna Convention on the Law of Treaties. I've written separately about how rules of procedure should assist in this outreach, including through consultation with relevant international organisations and amicus briefs from NGOs. The prospect of mixed disputes is also an important one to raise. There is some uncertainty about the operation of dispute settlement bodies in the trade context, given the current vacancy of the appellate body, but the key point is really one of flagging that disputes over the rights and obligations of states regarding the protection and preservation of the marine environment could arise in different forums. In conclusion, I have shown today that the protection and preservation of the marine environment is a general obligation of states that is increasingly viewed through the lens of the production and consumption practices of citizens and consumers. Trade measures, rules on fisheries subsidies, and marine protected areas are all relevant to the rights and obligations entrenched in trade agreements, including the WTO and regional agreements such as the CPTPP. Cooperation by states, whether direct or through competent international organisations, should proceed with an awareness that boundaries between economic, environmental and social goals for the protection and preservation of the marine environment are not immutable. Thank you.
Thank you very much, Professor Young, for a very comprehensive presentation. You have given us food for thought, particularly on issues relating to possible inconsistencies and overlaps between law of the sea and international trade law, because it raises issues of potential conflicts between international legal regimes and their respective dispute settlement mechanisms. And the ongoing fishery subsidies negotiations within the WTO, of course, present one such problem. But I think these problems arise in today's international legal system because they are parallel rule-making bodies and dispute settlement mechanisms with no hierarchy. However, we think that given the common objective of the exercise, which is to preserve marine resources, both under UNCLOS as well as WTO, hopefully the final outcome would respect the respective mandates of the two regimes.